Judges could please introduce themselves.
Good afternoon. I am Jay Barth. I'm the Chief Education Officer for the City of Little Rock, Arkansas, and a retired American politics professor at Hendrix College. Welcome.
Hey everybody, my name is Thomas Mackey. I'm in the History Department at the University of Louisville and the Brandeis School of Law at the University of Louisville.
I'm Rita McCann, and I'm a plain vanilla lawyer from North Alabama. I live in Huntsville, Alabama, just right close to the Tennessee state line. And we're really glad to hear from you guys today.
And if you want to introduce yourselves in whatever order.
Hi, my name is Ananya Shah, and we are all from Maggie Walker in Virginia.
Hi, my name is Elizabeth Celentano.
Hi, my name is Amanda Perez, and our coach is Mr. Olmsnyder, and Amanda will look like that because she used to live in Huntsville, so actually.
Great. Well, welcome, and we look forward to your answer to this question, which is for Unit 3, and it's the first question, and it's a quote. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Next, is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? We'll let y'all take it away.
Alexander Bickel wrote, "When the Supreme Court declares unconstitutional a legislative act of an executive, it thwarts the will of representatives of the people, and it exercises control against the prevailing majority." However, the court rarely acts as Bickel feared. As a weak institution, many of its high-profile rulings follow public opinion. In his critique, Bickel was responding to Brown v. Board, a decision which led to severe backlash against the court. The backlash, though harmful to the court's public legitimacy, did not represent a national majority. A 1954 Gallup poll found while 71% of Southerners disagreed, 54% of Americans supported it. The court made a counter-majoritarian decision by contradicting the Arkansas state legislature, but it followed national opinion. Similarly, in 2015, the court followed public opinion on same-sex marriage. At the time of Obergefell v. Hodges, the Pew Research Center found 57% of Americans supported same-sex marriage, a dramatic change from 2010 when only 42% supported it.
However, the court often allows unconstitutional limitations upon minority rights when acting majoritarian. In 1951, the court effectively banned Communist and Socialist Party speech in Dennis v. U.S., following rising anti-communist sentiment. When the court does act counter-majoritarian, it often defends the constitutional freedoms of disliked minorities from local majorities. For example, in Engel v. Vitale, the court invalidated state-sanctioned school prayers, reaffirming First Amendment rights against establishment of religion. The court even protected KKK speech in Brandenburg v. Ohio.
The Federalists would have agreed with Holmes and disagreed with Bickel, as Hamilton wrote in Federalist 80. 13 independent courts of final jurisdiction over the same issues is a hydra in government from which nothing but confusion can proceed. Judicial review has impacted federalism by intermittently expanding national government power. Article 3, Section 2 specifies when the Supreme Court has original and appellate jurisdiction. In Fletcher v. Peck, the Supreme Court used judicial review to declare a state law unconstitutional under the Supremacy Clause for the first of over 950 times.
Cases involving the Commerce Clause exemplify how judicial review expands federal power, especially congressional authority. The court revolutionized the Commerce Clause by upholding the constitutionality of the Agricultural Adjustment Act in Wicker v. Filburn. The court approved congressional regulation because many farmers producing excess wheat for private use would substantially impact interstate commerce. Wicker set a precedent for a broad understanding of federal regulatory power post-New Deal, like in Garcia v. San Antonio MTA, where the court ruled the Commerce Clause gave Congress power to require state and local governments pay employees minimum wage.
Also, the Chevron deference established in Chevron v. Natural Resources Defense Council impacts federalism. The Chevron deference means courts defer to the interpretation of a statute made by the government agency enforcing it unless it is unreasonable. This use of judicial review to evaluate the meaning of federal laws and not just constitutionality has further limited state power. Likewise, incorporation has narrowed state sovereignty. For example, in Robinson v. California, incorporation of the Eighth Amendment nullified a California law criminalizing narcotics addiction. The court's pattern of favoring federal power has exceptions. The court ruled in U.S. v. Lopez, the Gun-Free School Zones Act exceeded Congress's Commerce Clause powers. Justice Frankfurter said in Terminiello v. City of Chicago that jurists do not dispense justice according to individual expediency. Most limits on the court are self-imposed, like the strict necessity doctrine and stare decisis.
Imposing limits on the composition of the court to restrict judicial review would inherently impact rulings. Staggered 18-year term limits could ensure that no president has too many appointments and lower the partisan stakes of hearings. Similarly, a bicameral confirmation process rather than unicameral might create more bipartisan support for justices, given our post-1970s trend of divided government. This would also make the process less counter-majoritarian, as the House proportionately represents a national majority. The process would be less politicized, decreasing problematic decision-making on the court itself. Thank you. We are now ready for your questions.
So shall I jump in? Yeah, sure, I'll go. This is interesting. You're talking about this inconsistencies maybe with the application of judicial review, whether it's states or federals, but you see a trend overall of expanding federal power. And yet I thought we allow majorities to set public policy, that we allow democratically elected majorities to set public policy. And yet you folks seem to be very positive about 9 unelected, unaccountable people in robes in Washington, D.C. frustrating the will of majorities. Help me understand that friction a little bit better.
So I would push back upon the idea that the 9 justices do not have any checks against them. First, they are dependent on the executive enforcing their decision. For example, in Worcester v. Georgia, President Jackson did not follow the court's opinion and proceeded with the removal of Indians on Cherokee land.
Furthermore, in cases like Chisholm v. Georgia, which was about the court ruling about the states being sued, the courts were actually limited by the other branches of government. Following Chisholm, the Congress and the states immediately approved the 11th Amendment, which actually limited the Supreme Court's jurisdiction in regards to states being sued and them judging cases involving states being sued.
There's also this idea that the Constitution represents a continual democratic majority, and that the justices, by continuing to reaffirm that those principles in the Constitution under the Article 6 Supremacy Clause does remain supreme, and any statutes that fall under it are subject to the standard of the Constitution, which the justices must uphold.
Let other folks jump in. Go ahead.
What do you think about the replacement of one justice for another? For example, when Justice Ginsburg died last year, do you think there is the claim that a single Supreme Court seat can change history is accurate? We've had a book written in the past 2 years saying that a single Supreme Court seat change can change history. Do you all agree with that? Disagree? What is your position, and and tell me why?
I would certainly agree that a single seat can be quite influential over how the court rules. For example, under Chief Justice Warren, the court made several progressive decisions within the civil rights movement, which did alter the trajectory of the court and the trajectory of American societal belief in politics for years to come.
Many contentious court cases actually have been decided 5-4, proving the importance of one Supreme Court justice. For example, Bush v. Gore was initially in regards to the equal protection application, in regards to returning and having equal standard applied across every single Florida county, was actually decided 5-4, and some of the nuances besides it being a 7-2 overall opinion.
So, over time, there are certain types of cases that the court has made a choice not to engage in, not to intervene in. Do you think that there has been, if you could talk just a little bit about that, but my question is really, do you think there has been any real principle in that pattern, or is it really very much a political process itself, the court making choices about when it wants to intervene based on, the whims of the moment and the membership of the body?
I think that there certainly is the doctrine of the political question doctrine that is clearly demonstrated when the court will and will not rule upon certain issues. For example, we see this in Goldwater v. Carter, which was about the Sino-American Treaty and whether Carter had the ability to unilaterally withdraw from that treaty. And so clearly in matters of like foreign affairs, which are clearly delineated within the Constitution, like with the Article 2, Section 2, president's ability to have treaties with advice and consent of the Senate, there's clearly certain issues that are clearly in the Constitution given to other branches that the court will not rule upon and have determined to be a political question because it's about the relationship between Congress and the president.
Continuing on the theme of the political question doctrine, it also allows the court to reaffirm its institutional legitimacy in the public arena by neglecting to become involved in political questions such as partisan gerrymandering, which the court ruled in Richmond v. Common Cause that it is not an issue for the courts, but the court has ruled that racial-based gerrymandering is subject to strict scrutiny and does become involved when there are questions of the 14th Amendment.
That is not to say that judicial activism decisions have not been made in the past. The most infamous decision that the court has made in Dred Scott v. Sanford was ruling that slaves under the Fifth Amendment were property and could never be citizens, could be classified as a judicial activist decision because Chief Justice Taney not only decided the case of Dred Scott, but also declared the Missouri Compromise unconstitutional, which then led to President Lincoln campaigning on the issue and eventually did force conflict between the North and the South.
Yeah, I want to circle back to, it's not really even circle back, but push you a little harder on your sort of argument, maybe implicit argument here of the Supreme Court, maybe the federal courts generally, of being political actors. And yet I thought since the founding forward that part of the strength of the federal judiciary, or the Supreme Court in particular, was its independence. So are they political actors or are they independent? Help me understand that relationship.
So I think it really can't be an either or situation. It's more based on the case itself. The judiciary is not completely independent, although in Federalist 78, Hamilton lays out the life tenure and its compensation as allowing for it to be independent. But the court is reliant on public legitimacy in a certain aspect as well.
Furthermore, Justice Breyer has recently articulated in the Antonin Scalia lecture at Harvard Law School that the court, when it does make these contentious, someone call political or just broadly impactful on American public decisions, they are instead reaffirming beyond normal jurisprudence, they're reaffirming underlying American values and values in the spirit of the Constitution, and they're considering the future impact. So it's not merely considering the jurisprudential things when they rule broadly and deeply rather than narrowly.
I would also argue that the justices on matters of clear constitutional interpretation, such as First Amendment cases, Fourth Amendment cases, they do rule a certain way, such as substantially always protecting hate speech. However, on issues that historically were open to interpretation, such as the right to privacy in Roe v. Wade, they do need to consider their impact on public legislation.
Very good. Thank you. Please take a breath. You said a lot of words, and they were very, very good and well thought out words. So congratulations on a very nice job. I'll turn it over to my colleagues for comments, and then I have a few as well.
Sure. Again, at times it's almost an avalanche of ideas and arguments and cases. Whoa, take a breath. Slow down a little bit. I know it's exciting. We were a little nervous and maybe a little excited. It's good. That's great. But it was, if anything, it was way too much. I'm delighted, those strings of cases, but golly, sometimes a little less is actually a little more. So now, having said that, I really like what you did. I think you're really good at surveying the areas, cutting to the major issues, and taking a position and defend it. So I really thought this was a really solid, nice job overall. Nice.
Well, and he said you had too many cases, but then when we asked you about them, you knew what you were talking about. We have had to ask other groups today, and they didn't know what the cases were about. They just knew to read them off in the right places. I guess what makes me all warm and fuzzy and want to start crying again is that not only know what you're talking about, but you emote that you know about it and that you understand it, and you use words that are longer than I can spell to explain things, and that's wonderful. Whatever you're learning, keep learning it, and whatever you're absorbing, use it to make yourself a better adult, because y'all are the kind that I have a colleague here, and I'm not going to name names, who not with us, but in another judging group, who always loves to say up on Capitol Hill, look around you. You can be here. You can shoot for being one of these representatives, being one of these senators. You guys certainly can. Y'all can go across the river and be one of those senators, be one of those representatives for all of us. And I, for one, will appreciate it. Particularly, pardon me, gentlemen, particularly the fact that you are women and that there are some that look like you who are up there and who are representing, and you can just follow in their footsteps. I'm just really proud of what I've heard today. Thank you.
Thank you so much.
Thank you.
Yeah, I agree with everything that's been said. I think I probably differ a little bit from Tom's comments about too much, because it was, you in every case took that next step and really showed you had a depth of understanding about the case. It was not just a case name or even a case name and a topic, but you really understood the connection of that case to the broader principles, the broader argument. So I was very impressed. I thought this was amazingly well done. I would have liked to turn it down, the speed down a notch, so I could listen a little bit better. It was flying. It's hard to critique because you knew the stuff so well that you just were able to use it aggressively and assertively, and it's hard to criticize that. I do think you might have been. I think you were constrained by the format. I do think don't be guided by this format when you move beyond here. When you do go to Congress, do slow things down a little bit and allow people to listen and soak in your words rather than be basically, overwhelmed by your words.
Thank you so much for taking the time out of your, I'm sure, busy schedules, and also taking the time on a weekend to judge us. We really appreciate it. And you guys had some really wonderful questions.
Thank you so much.
Yeah,
Wish you
good
you
luck
made
with everything.
Volunteers keep this program going. Thank you.
Right.
Yeah, no problem.
The fact that you guys have overcome the technology, not only that, of course, it's overcome for adults. For y'all, I'm sure it's not overcoming anything, but the fact that you're willing to take that on when that's the way we've had to live our lives, and the fact that you were able to prepare this very, very great material has been real impressive to me, and I appreciate it.
Thank you.
Fantastic.
Nicely done, folks. Start breathing. It's okay.